Hello, I'm Phillip Taylor. I'm talking about this book, Guidelines for the Assessment of General Damages in Personal Injury Cases. Very important work. I've given it a title in a number of the reviews that I have had published on the internet as the PI Bible for and from the judges. On the back of the book, and you can see from it the way that it's laid out in its various chapter headings, it gives you a very useful indication of the amounts that we're talking about for the different types of injuries. On the back it actually describes the book in its 9th edition as designed to provide a clear and logical framework for the assessment of damages in personal injury cases. And it says the first edition of the title was regarded as a landmark for PI practice because obviously the issues since then have built up the picture, and the current edition obviously has taken into account inflation, bearing in mind that this current edition is relevant in the year 2009. It's been written by a working party of people, so there are a huge number of people involved. Let me talk a little bit about it. I use it regularly in court, and it's useful both, not just from the point of view of quantum issues, but it's useful when you're dealing with the client and explaining how we arrive at some of the figures that we get to, because there's a little bit of distress, frankly, about what certain things are worth, and it's bound to be a problem, and controversial, of course, too. What I've said in the written review, and as I say, I really am very, very pleased that they've produced this book. The book actually first appeared in 1992, and at that time Lord Donaldson said that there could be no doubt about the practical value of this volume. Of course, then it's become essential, and JSB Guidelines obviously now are something I will certainly look at as a very first consideration when I'm looking at a brief. They're always well received, and they've got a clear, well received influence on the judiciary, in my view, from practicing in, as I do, the county courts. Colin Mackay, who's actually the current compiler editor, says that the current need for the work is a record of the levels of awards and settlements which have been achieved. Obviously that's the reason that we need it today, and it's a starting point for our own advocacy, of course. Now, updates are always going to be difficult, and Mackay and his team have produced the level of consistency, I think, which is needed for the making of awards, and it serves the interests of justice as well as any person can by having something of this nature. I hope we have more of this sort of publication in future, because it doesn't make the judiciary quite as remote as they obviously appear to the lay client. Now, Lord Justice Waller, in his foreword, makes some comments. It's actually on the back of the slim volume as well, but he welcomes the work, and he highlights the comments from some of the book's readers, together with all the different areas where the reports are to be found, and obviously he makes the working party's job, which he knows is difficult, he knows that it makes it a lot easier. It's not, though, and should never be perceived to be, a ready reckoner, but Mackay says that it distills the conventional wisdom contained in the reported cases and supplements it from the collective experience of his working party. And obviously he's only going to be able to do that if we supply a certain amount of the information about the type of quantum we get in a particular settlement. But certainly the result is presenting a document which is in a convenient, logical and coherent form, and that's exactly what it is. Obviously the contents cover a huge number of areas. I'm not going to go into them, but they deal with everything that you're really looking at. I can't be without my copy of the JSP Guidelines. I know that the clients appreciate the wisdom they give, and it's something I think we as advocates should all be very much at home with. So thank you, Mr Justice Mackay, and your team. Bye bye.